It is March 31st of 2026, and this is the Court Gallery. Welcome, ladies and gentlemen. In today's compilation, we're stepping into the courtroom for 6 intense cases. We kick things off with 2 cases before Judge West involving serious felonies and assaults on first responders. Then we move to Judge Stevens for a chaotic probation hearing that ends in a shocking family outburst and instant contempt. Next, Judge McNally tackles 2 cases, including a yawning defendant trying to explain away 23 technical probation violations. Finally, we wrap up with Judge Middleton, where a defiant probationer tries to blame his attorney for all of his problems. These judges have absolutely zero patience for the excuses today, and it all starts right now.
Is he even want to court? Did he say? I don't know. He needs to start coming up on some side. I will. Good morning. Are you Steve Ray Williams? I need you to speak up since you have that. Are you sick?
No.
Okay. So, will your client waive the formal reading of the indictment in each case?
He does, Judge.
There's 2 MTRPs and 3 new cases, I think, and on that other one. All right. See, will he waive the formal? Did I already say this? He'll waive the formal reading in all the cases. Sorry. All right. Let me start getting them pulled up here. Are they all? Well, I know the unauthorized use is enhanced.
You're all. Yes, Judge.
Okay, so I need to make copies of me. If you want to start at the end of Mr. Williams, and print some of those, I'm gonna have to make notes on all of those because it's different counts. Please, ma'am. I've got the first one I'm getting started and I'll go that way, but give me just a second,
Okay, check this.
to get it. When I need to make notations on them, it's easy if it's 1 or 2 on the computer. It's not if there's a lot. So let me get everything printed out, and it'll take a minute, but it'll go quicker once I get it done. All right, let's get started. Mr. Williams, in clause number 26, DCCR 0312, you're charged with the state jail felony offense of unauthorized use of a vehicle, and that's from December 2nd of 2025. Your indictment alleges that you were previously convicted of possession of a controlled substance, a state jail felony, March 25th of 2002. And after that was final, you were convicted of possession of a controlled substance, a state jail felony, May 22nd of 2024. And how do you plead to that charge?
Guilty.
Speak up, please.
Guilty now.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with? I need you to answer out loud.
Yes, ma'am.
And are those prior 2 convictions true?
Yes, ma'am.
In cause number 26 DCCR 0313, which counts are we going on that case?
See.
I printed the first 3.
There's a have listed as a habitual, but there's only one additional felony alleged there. I don't know if I didn't file a notice to enhance a standalone, yes, I did.
Yeah, so
I
that's when you
filed a
filed
notice, a standalone notice in all of the cases to enhance it.
Is he pleading to all those counts?
Yes, ma'am.
So with the minimum of 25?
Yes, Judge.
Okay, so. Hold on a second.
It may.
Let's go back to,
I was gonna suggest maybe refer to the notice of enhancement that I filed. I don't know if it would make it easier that way.
I'm gonna go back to the cause number ending in 0312. It's the one you just pled guilty to. It had those two prior state jail felony offenses listed in the indictment. The state has also filed a notice of intent to use prior convictions to enhance. And in that, they allege that you were also previously convicted of the second degree felony offense. No, hold on. Prior convictions, there we go. Of possession of a controlled substance. It doesn't say what level offense that is, but that's the one from July 30th of 2003. What level offense is?
He received 5-year sentence on that, Judge. Let's see. To be clear, to be specific, it was, looking for judgment now, a first degree felony. Judge.
So that conviction, again, from of possession of a controlled substance from July 30th of 2003, which was a first degree felony. Is that true or not true?
Yes, ma'am.
And then there's also an allegation of a conviction from March 11th of 2008 that you were convicted in the United States District Court for the Eastern District of Texas of the offense of felon in possession of a firearm. And is that also true? And so what that means is that for punishment purposes, in this case, the punishment range would be that of a second degree felony, which is between 2 years and 20 years. Is that your understanding?
Yes, ma'am.
And again, did you enter your plea of guilty and true to those prior convictions freely and voluntarily? Yes. All right. And cause number 26 DCCR 0313. You're charged with unlawful possession of a firearm by felon, third degree felony from December 2nd of 2025. The indictment alleges you were previously convicted of possession of a controlled substance, a first degree felony, July 28th of 2003. And then the notice of intent to enhance alleges that same prior that we already talked about, which is the felon in possession of a firearm case, which was the federal case from March 11th of 2008. How do you plead to this charge?
Guilty, ma'am.
And again, are those prior convictions true?
Yes, ma'am.
And did you plead guilty and true freely and voluntarily?
Mm-hmm.
And in this case, that makes the punishment range that of a habitual offender. Is that everyone's understanding?
Yes, Your Honor.
Yes, Your Honor.
Then in cause number 26 DCCR 0314, you're charged with the second degree felony offense of abandoning or endangering a child within placing them in risk of imminent bodily danger. And that's a second degree felony from December 2nd of 2025. And how do you plead to that charge?
Guilty, ma'am.
And then that indictment also alleges that you were previously convicted of possession of a controlled substance, a first degree felony, July 28th of 2003. In addition, that notice of enhancement alleges that prior conviction of felon in possession of a firearm, making this habitual punishment. Do you understand?
Yes, ma'am.
And again, are those prior convictions true?
Yes.
Cause number 26 DCCR 0315, you're charged with the state jail felony offense of theft of a firearm. And that's from December 2nd of 2025. That indictment alleges those prior state jail felony convictions, the possession of a controlled substance from March 25th of 2002. And then after that was final, the state jail offense, possession of a controlled substance from May 22nd of 2024. In addition, there's the two prior felonies that are listed in the notice of enhancement, the felon in possession of a firearm, as well as the possession of a controlled substance, which was a first-degree felony. And how do you plead to this charge? And again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And also, are all those prior convictions true?
Yes.
And then finally, in cause number 26, DCCR 0316, you're charged with a first-degree felony offense of aggravated kidnapping from December 2nd of 2025. And how do you plead to that charge?
Guilty now.
And that alleges in the indictment the prior offense of possession of a controlled substance, a first-degree felony, July 28th of 2003. In addition, there is the notice to enhance that alleges the prior felon in possession of a firearm from March 11th of 2008. And are all of those prior convictions true?
Yes, ma'am.
And that for punishment purposes makes this a habitual offender, correct, everyone?
Yes, ma'am.
Did you enter your pleas of guilty and true in all of these cases freely and voluntarily?
Yes, ma'am.
And did you plead guilty in each of the cases because you actually did what they've charged you with?
Yes.
In all of these cases, I have here on the tablets and documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney in each case that you'll be waiving or giving up any right to appeal?
Yes.
It's going to take me a minute to get them all printed out. And state tenders number 1 in each case.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Williams is not competent?
No, Judge.
And Mr. Williams, do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
Give me just a second. So is it 20 on the 2
State jails.
and 35 on all of those?
That's right, Judge.
All right, this is going to take just a minute. I've got to go through each of those documents and print out the admonishment or the certification. All right, sir, in each of your cases, I'm going to find that you entered your pleas of guilty and true, freely and voluntarily. Find again, you're mentally competent and understand the nature and the consequences of all of those pleas. And cause number 26, DCCR 0312, find sufficient evidence to find you guilty and find all those counts true. And in that case, sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 26, DCCR 0313, find sufficient evidence to find you guilty, find those prior counts true, and at this time find you guilty of unlawful possession of a firearm by a felon, sentence you in accordance with your agreement to a term of 35 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 26, DCCR 0314, find sufficient evidence to find you guilty, and at this time find you guilty of abandoning or endangering a child. Find those prior convictions true. Sentence you in accordance with your agreement to a term of 35 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 26, DCCR 0315, find sufficient evidence to find you guilty and find all the prior convictions that you pled true to true. And at this time, find you guilty of theft of a firearm, find those convictions true, sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in clause number 26, DCCR 0316, find sufficient evidence to find you guilty. And at this time, find you guilty of aggravated kidnapping, find those prior convictions true, sentence you in accordance with your agreement to a term of 35 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. All of these cases will run concurrently, which means together at the same time. Handing you in each of your cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, and you obviously know this because it's one of the charges and you've had the charge in the past, but I'm required to read this to you by law. So because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, good luck to you, sir. You can go back with the bailiff.
Yeah, that's sure.
What? Okay. Are you Kevin Lee Tran?
Yes, yes.
And Mr. Lewis, will your client waive the formal reading of the indictments and the motions?
He does, Judge.
Mr. Tran, in clause number 25, DCCR 0423, you're charged with the second-degree felony offense of assault on a peace officer from March 14th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
This was in there. And are you pleading guilty because you actually did what they charged you with? Sorry.
Yes.
And then in clause number 25, DCCR 0424, you're charged with the third-degree felony offense of assault on EMS personnel from March 14th of 2025. And how do you plead to that charge?
No contest.
Is it you're either guilty or
Yeah,
not guilty?
guilty.
And are you pleading guilty freely and voluntarily?
No.
And because you did what they charged you with? In those two cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes.
Do you fully understand them? And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Speak up, please.
Yes.
And Your Honor, I would ask the court to take judicial notice of the letter dated March 12, 2026. So throwing it in the first.
In what case?
All of these cases, Your Honor,
Okay, hold on.
Mr. Tran had been evaluated, was incompetent for.
Oh, hold on. Okay. Hold on. Thank you, Mr. Nicholas.
Yes, Your Honor, I should have done it at the onset, sorry.
Sorry, they're not in together. Okay, here we go. It's okay. I know. I just have to say it out loud. All right, I'm going to take judicial notice also in all of the court's files. And hold on a second. Mr. Tran was evaluated for competency and was found not competent to stand trial back in August of last year, was sent to the John Dunn Behavioral Science Center for competency restoration, received the report from them dated March 12th of 2026 that has the finding that Mr. Tran has attained competency and is currently competent to stand trial. Is there any other evidence with regard to competency?
Not from the defense, Judge.
Not from the state. Your Honor.
Okay. Then at this time, based on that report, I will find that Mr. Tran is competent to stand trial. So now I gotta go, where was I? All right, so I went through clause number 0423 and 0424. And so, Mr. Tran, did you go over the paperwork on the tablet with Mr. Lewis?
Yes, Your Honor.
And you fully understand it?
Yes.
And you understand if I follow the agreements that you've made with the district attorney that you're waiving your right to appeal?
Yes, Your Honor.
State tenders number one in each case.
No objection, Judge.
They're admitted in each case. Again, I'm going to find that Mr. Tran is competent to stand trial. Mr. Tran, I'm going to find that you entered your pleas of guilty in each of these cases freely and voluntarily. Find sufficient evidence to find you guilty, and in cause number 25 DCCR 0423 finds you guilty of assault on a peace officer, sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 25 DCCR 0424 find sufficient evidence to find you guilty, and at this time find you guilty of assault on EMS personnel, sentence you in accordance with that agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 21-37560, I have a motion to revoke your community supervision. This shows that you were placed on probation February 16th of 2022 for the state jail felony offense of theft of property. And that was a 2-year term in the state jail prison that was probated for 5 years. Is that correct?
Yes, Your Honor.
And Judge, count one is one of the offenses we just pled to. Count two is one that's being dismissed. We could just do count one of these. That's all right with the court.
1 and 3.
Yes, Your Honor.
Just as. And then in cause number 21-38780, I also have a motion to revoke your community supervision. This shows that you were placed on probation February 16th of 2022 for the 3rd-degree felony offense of assault family violence by impeding breath or circulation. And that was a 5-year term in prison that was probated for 5 years. Is that also correct?
Yes, Your Honor.
These cases each allege that you violated your probation. Count 1 in each case alleges that you committed the new offense of assault on an EMS personnel, the one that we just went through, from March 14th of 2025. And is that true or not true?
Yes, it's true.
And then count 3 in each case alleges that you committed the new offense of assault on a peace officer from March 14th of 2025, also the other case that we just went through. And is that true or not true?
Yes, Your Honor, it's true.
Did you enter your pleas of true in each of these cases to counts 1 and 3 freely and voluntarily?
Yes. Yes.
And did you plead true to those counts because those counts are actually true?
Yes.
In each of those cases, I also have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Did you also go over these with Mr. Lewis?
Yes.
And do you fully understand them?
Yes, Your Honor.
And again, you understand if I follow these agreements that you'll be waiving or giving up any right to appeal.
Yes, Your Honor.
State tenders number 1 in each of these cases.
No objection.
It's admitted in each of those cases. All right, Mr. Tran, in each of these cases, in cause numbers 21-37560 and 21-38780, I'm going to find that you enter your pleas of true to counts 1 and 3 freely and voluntarily. Find those counts true. And 21-37560, find sufficient evidence to revoke your probation. And at this time, revoke your probation. reassess your punishment in accordance with your agreement to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 21-38780, find sufficient evidence to revoke your probation, and at this time revoke your probation, reassess your punishment in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. All 4 of these cases will run concurrently, which means together at the same time. I'm going to hand you the trial court certifications in all 4 cases that shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. I have just signed a dismissal in cause number 25 DCCR 0422 as part of that agreement as well. Good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
Thank you. You good?
And 24 CR 2199 is now called the State of Texas versus Jonathan Brazino. There's a motion to revoke unadjudicated probation. This is not an agreed matter, correct?
That's correct, Your Honor.
All right, so take a seat right over here, sir. Thank you. And the defendant is represented by Mr. West, and the state's attorneys are present. There is a motion to revoke probation that was filed in December of 2025. Does the defendant waive a formal reading of this? Can we proceed in summary?
Yes, Your Honor.
In summary, and by the way, raise your hand, sir. Do you solemnly swear or affirm any statements that you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God? You have to speak out? Yes, sir. Lower your hand. In summary, this motion to revoke probation states that on January 13th, 2025, in this court, you were placed on 10 years deferred or unadjudicated probation for the 3rd degree felony of assault, family violence, assault of a family or home member by impeding breath and circulation. Is that true that you pleaded guilty and were placed on probation January 13th of 2025 for that 3rd degree felony?
Yes, not for the probation.
And you were placed on deferred or unadjudicated probation for a period of 10 years.
Yes, sir.
All right. Now, here's what the allegations are. Number 1, this states you committed the offense of burglary of a habitation on or about October 7th, 2025 in Jefferson County, Texas, in violation of condition 1 of your probation order, which states don't commit a crime. Is that true or untrue?
It's true.
That is true?
Yeah. But I didn't burglarize the home though.
No, it's a, no,
Well, it's not true.
it's not, okay. Yeah, don't make a mistake there.
No.
You're either pleading true or untrue.
Basically, true.
All right. 2, you committed the offense of violation of a protective order on or about October 7th, 2025 in Jefferson County, Texas, in violation of your probation order. Is that true or untrue?
Untrue.
3, you were at a location other than your residence at approximately 11:57 p.m. on or about October 7th, 2025, when you were arrested, which is a violation of condition 18 of your deferred or unadjudicated probation order, which states that, stand by, that you must be inside your home every day between 10 p.m. and 6 o'clock a.m., except for employment purposes. Is that allegation true or untrue?
I was arrested in my.
Or is that untrue or true?
Untrue.
4, you failed to provide verification of performing community service hours as required to the probation office in violation of condition 7, which states that you says failed to provide verification of performing community services in condition of 17, which is perform 600 hours of community service restitution. And the allegation is you failed to provide the or show verification of performing community service hours as required. Is that true or untrue?
That's true.
5, you failed to provide verification of entering and successfully completing the battering intervention and prevention program called BIP, BIPP. And that is also an anger management program. That was directed by the probation officer in violation of condition 26 of your deferred probation order, which is complete BIPP/anger management and pay all associated costs. Is that true or untrue?
True.
I'm going to skip the failing to pay fees. 7, this states that you had contact with the complainant in this case, either in person, by telephone, via mail, or through a third party on or about October 7th, 2025, and you were arrested for some charges, I don't know, in which the victim is also the victim in your current probation case. I'm a little fuzzy on this. In violation of condition 27 of your probation order, this condition 27 states you shall have no contact with the victim of the offense, either in person, by telephone, via mail, electronic mailing, or social media, or through a third party. Is that true or untrue?
Untrue.
What'd you say?
Untrue.
Untrue. Are you pleading true to allegations 4, failing to provide verification of performing community service hours as required, and 5, failing to provide verification of entering and successfully completing the batterers intervention and prevention program for anger management program?
Yes, sir.
Are you pleading true to those allegations 4 and 5 of this motion to revoke probation voluntarily and because those are true as they are alleged?
Yes, sir.
Do you understand that a voluntary and knowingly made plea of true to one or more violations of probation, that's all it takes for the court to grant the motion to revoke probation if it's proven by a preponderance of the evidence or greater? Your probation can be revoked and you can be sentenced to no less than 2 nor more than 10 years confinement in prison.
Yes, sir.
Knowing that, do you insist on pleading true to allegations 4 and 5
Yes, sir.
of this motion to revoke probation?
Yes, sir.
I find that the defendant has pleaded true voluntarily, knowingly, intelligently, and 4 and 5 allegations in this motion to revoke probation are proven true by preponderance of the evidence or greater. All right, the state may continue presentation of evidence in this matter. Raise your right hand. Do you solemnly swear or affirm any testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please have a seat, sir. Thank you. Go ahead.
Good afternoon. Could you please state your full name for the record?
Donald James Jackson.
How are you employed?
Officer, you're going to have to turn that microphone toward your voice so we can hear you because it's what we call a directional mic. You have to kind of speak right into it. Okay, go ahead. Do that again.
You state your full name.
Officer Donald James Jackson,
How are you employed?
Port Police Department,
How long have you been with Port Arthur?
5 years.
What kind of training and experience do you have to go through to become an officer with Port Arthur?
I gotta go to school there, electrical or some form of police academy, and then I got training for 3 months.
And you've completed all of that training?
I have,
Are you a certified peace officer?
yes,
You currently keep up with any continuing education that you might need to have to be? Were you employed with Port Arthur Police Department on October 7th of 2025.
Yes, ma'am.
What were your shifts like at that time? What time were you
I
working?
worked each shift from 2:30 PM to midnight.
And were you working on October 7th of 2025? Were you on shift?
Yes,
About nearing the end of that shift, around 11 o'clock, did you receive a call?
Yeah.
And where did you go as a result of that call?
35 minutes time he came out at a possible kidnapping.
And that was what the call that you received through dispatch? 3535 Thomas Boulevard, is that in Port Arthur, Texas, in Jefferson County, Texas? What happened when you got to that address?
When I arrived on scene, I approached the house, front door was open, lights on. I did observe a broken window to the left of the house. I waited a moment to see if anybody was screaming inside or anything like that. Few moments later, there was movement in the house, a dog and several children, small children were crying. I gave instructions for anyone inside to come out. Older woman approached and said that male subject came and took her daughter.
So all of this, you're just kind of gathering some information of what might have happened before you arrived, why someone would have called 911. You're just kind of doing an overview at this
Yes.
point. Were you the first responding officer on the scene?
Yes,
Were you patrolling nearby? That's why you were able to get there
Yes.
first. So you said when you got there, you noticed that the lights were on. You also said you noticed that there was a broken window. Did you investigate that broken window any further?
yes.
What were your observations of that window?
As I was walking through the house, I found blood splatter, leading from inside the house, through the bedroom, the hallway to the front door. The glass looked like it was broken outside in, so, large pieces of glass was inside on the bedroom floor. It appeared that somebody was attempting to or did enter from the outside into the resident by the window.
Through that window that you observed.
That's good.
Did you speak with anybody on the scene?
Yes,
Do you remember who you spoke with?
I don't remember her name off the top of my head, but it was the mother of the victim.
You mentioned there were some children on scene. Did you speak with them at all?
No.
And what did you gather, without saying what the mothers told
Perfect.
you, what did you gather from the conversation that you had with her?
That the victim's ex-husband boyfriend, was inside the house, unwanted, they didn't want him there. They got into a physical altercation, and when the mother left to go grab her cell phone, call 911 and return, both her and her daughter was, him and her daughter was gone.
So she was the one that actually made the call to y'all. Did anyone else from your department arrive on the scene?
Yes,
About what time was that, do you think?
about 5 minutes after I made initial contact.
And when we were speaking upstairs, you mentioned that this was about shift change, so it might have been people coming in on a new shift as you were. And that's correct?
Yes,
So during your investigation, did you identify the victim's name?
yes.
What was her name?
It was Mackenzie Vincent.
Vincent? And throughout your investigation, did you learn whose bedroom or room was where the window was
Yes, I
broken?
did. The mother told me it was her daughter, Mackenzie's.
So it was Mackenzie's bedroom at the house that the window was broken.
Correct.
And how did you know, based on your training experience, that it was broken, or you assume that it was broken from the outside into?
Because the glass was gathered inside, when you break a window, it's usually whatever force propels it in the same direction. From the outside in, it's going to go towards whatever, like when you throw a baseball, the shards will go how the baseball was traveling forward.
Were you still on the scene when Mackenzie came back to that house?
Yes.
Did you speak with her personally?
I didn't, but I, kind of overheard, the conversation between her and another officer.
I know that this case wasn't eventually filed as a kidnapping as you first thought when you responded. At what point did you make that determination to change the kind of investigation?
Uh, when she returned and stated that she wasn't, kidnapped, she actually left the resident of her own free will to return, to try to get property that was taken from the house.
That was taken from her when she was at her house. Did you take any statements from Mackenzie?
I did not, personally take any statements. I was there, I'm seeing why officers were writing written statements.
So after doing the initial investigation and remaining on scene until additional officers on the new shift took over, did you have any other involvement in this case?
No, no.
You returned to service?
Yes, ma'am.
Nothing further.
Hold on just a second. Okay, this allegation here is allegation number one, which alleges that the defendant allegedly committed the offensive burglary of a habitation on or about October 7th, 2025 in Jefferson County, Texas.
Yes, Judge.
Right. Right. And burglary, a person commits the offense of burglary if without the effective consent of the owner, the person enters a habitation or building or other portion of a building or any portion of the building not then open to the public with intent to commit a felony, theft, or an assault. Those are the elements
Yes,
of
Judge.
burglary of a habitation. So here, the defendant, without the effective consent of the owner, the person who had control over the dwelling, the lady, in this case, entered a building, the home, with intent to commit felony, theft, or an assault. What? Of those three,
Theft and assault.
Theft and assault, Judge.
theft and assault is
Yes.
what you're alleging.
Yes.
Okay. Okay. Go ahead.
I don't have any further questions.
All
from
right,
this
she
witness.
passes the witness. Go. Defense may cross-examine.
Good afternoon, officer. This may sound like a silly question, but obviously you didn't see what happened out there, did you? You didn't see the event happen, did you?
No.
Okay, all right. You're basing your opinion on what you were told by the people at the scene and what you observed at the scene, correct?
Correct.
Okay. But also you were told or you were made aware that she did cooperate with him and go with him and she wasn't kidnapped, was she? Right, she wasn't forced to go with him. She went with him voluntarily, correct?
Or she followed him.
Or followed him, however, yeah, maybe I was wrong words, but she did leave on her own free will, correct?
Correct.
That's what it's.
This man, you are excused, sir. Thank you. Next, please.
They calls Kate Carr.
Raise your right hand, sir. You solemnly swear or affirm that the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God. Yes, sir, I do. Please have a seat. Thank you.
Good afternoon, officer. Can you please state your full name for the record?
Kate Carr,
And how are you employed?
police officer with Florida,
How long have you been with Port Arthur?
over 7 years.
And are you a certified peace officer?
I am.
You've done all the training and continuing education that you would need to
Yes.
keep that license? Were you employed with Port Arthur back on October 7th of 2025?
I was.
What type of shift were you working back then? And what time frame is night shift?
9:30 PM to 7:30 AM.
Is that the one that's commonly referred to as midnights? Were you on shift on October 7th, 2025?
I was.
Were you called out anywhere around 11 that night?
Yes, ma'am, to 3535 Thomas Boulevard.
That in Port Arthur, Texas, in Jefferson County? What happened when you got to 3535 Thomas Boulevard?
I saw officers who were attempting to speak with someone in the house, but there was a dog that would let them in. And then once they were able to get the dog in the room,
the victim's mother came out, spoke to officers.
What was the initial reason for the call that you received through dispatch?
The initial reasons is an unknown disturbance.
An unknown disturbance. What did you observe after the mother came out?
She told us that her daughter, Mackenzie Vincent.
Objection, Your Honor, hearsay.
Sustain.
Sorry, Your Honor, I'll rephrase. Without stating what any other person said, what did you observe when the mother came out?
I saw a broken window on the south side of the house and left of the front door.
Could you tell from that point, that perspective, if the window was broken into the house or outside the
I did
house?
not.
Did you end up going inside the house and
I did.
continuing your investigation? What did you observe once you went inside?
Saw in that bedroom where the window was, there's a lot of blood on the ground, in the closet, near the bed.
So there was blood kind of throughout the room.
Yes.
Did you go to any other residences or places throughout this investigation? Where else did you go?
The address is, I believe it's 4100 Ashland.
And how did you come about going there?
I know that's where Racina's house is.
How do you know that?
Been there before.
Through your training and experience and your
Yes, sir.
job as a police officer, you've been there before. Why did you go there?
We thought that the victim had been kidnapped at the time.
And she might have gone there.
Yes.
Did you gather what the victim's name was?
Mackenzie Vincent.
What happened when you got to 4100 block of Ashland?
Saw her vehicle parked in the road running.
Mackenzie's vehicle?
Yes.
What happened after that?
Approached the house and the mother came outside and told us that he was not there, but that she was inside the house.
That Mackenzie was?
Yes.
Did you make contact with Mackenzie?
Did.
Did you eventually get her back to her own residence? Did she drive with you? Did she drive herself? So she wasn't harmed to your knowledge. What happened after you got back to her residence?
Back at her residence, she began speaking with other officers.
Were you present when she was speaking with those other officers?
Just a short time.
Did you discover that it was Brasina that broke in to her house? To your knowledge, I know you didn't speak with her for very long. To your knowledge, was she assaulted?
Yes.
At some point during your investigation, did you learn that she had an active protective order against Jonathan Brasino at the
I
time?
did.
And what usually happens? How do you find out that information? You
I
think?
asked dispatch to confirm it.
So
I'm
that
not sure how to do it, but they told me that she did have.
so they can look up records and then they can confirm something like that. What do you do in your training once you find out that there's a protective order against someone? Does that change the way you investigate at all?
If they're on scene, yes, but if they're not on scene, not much else we could do.
After you found out that there was a protective order, what else did you do?
I stood by with ID Tech while she took pictures.
And what was she taking pictures of?
Broken windows, blood. All I know of.
Did you determine who that blood belonged to?
I did not.
It didn't look like it was Mackenzie's
I
blood.
did not.
Say that again? What was your question?
It didn't look like it was Mackenzie's blood.
How do you know that? How do you know it didn't look like Mackenzie's blood?
Because of.
I mean, aren't all our blood's a reddish color?
Yeah, but we had looked at her and it didn't like she was bleeding from anywhere.
Oh, okay, she didn't seem to have any kind of
No, she was not
laceration. Good, okay, I understand. Go
There
ahead.
wasn't any cuts, apparent cuts on her, but there was blood, a significant amount of blood on the scene. And you observed the ID techs take photos of that. After the photographs were taken, did you have any other involvement in this case? Nothing further for this witness, Judge.
Good afternoon, officer.
You obviously didn't see what happened out there, did you? Okay, you're only basing your opinions on what you were told and what you observed when you got there, correct? Okay, all right. But you did know that you able to determine that Miss Vincent went to Mr. Brasino's house, correct?
Yes.
Okay, because that's where you found them, right? And then she drove back to her house. I guess you followed her or was first or whatever, okay? And there, y'all talked about being a lot of blood in the house, but it did not appear, I'm just gonna nail this home, did not appear that it came from Miss Vincent, did it? Is that correct? Okay. Did you ever determine who it came from? Okay. Awesome.
Nothing further for this one.
Oh, is this man excused?
Yes, Judge.
You are excused, sir. Thank you. Next, please.
State calls Mackenzie Vincent.
Come forward, please. And raise your right hand. You solemnly swear or affirm any statement you make during your testimony here today shall be the truth, the whole truth, and nothing but the truth, so help you God. Lower your hand. Okay, please move that chair, help her so she can get situated. Yeah, we'll help you on that. Then we need to move the microphone toward her voice.
Your face. Okay. And just ask that you speak into it so everybody can hear you, okay?
Kind of move up just a, with the chair, kind of just move up about 2 inches. That should do. Thank you. Go ahead.
You state your full name for the record.
Mackenzie Vincent,
How old are you, Mackenzie?
25,
Where do you live? Without saying your address, where do you live?
Port Arthur,
How long have you lived in Port Arthur?
all right.
Back in October of 2025, were you living in Port Arthur
Yes,
off of Thomas Boulevard?
yes, ma'am.
So we're here on an incident that happened on October 7th of 2025. Do you remember what happened on that date?
Yes, ma'am.
Where were you that evening on October 7th of 2025?
Just about to go to sleep. Laying in bed.
What happened? Were you able to go to sleep?
Ma'am,
Were you able to go to sleep?
I was trying to go to sleep until, I was getting, phone calls from Jonathan's mother.
And how do you know Jonathan?
Have his widow.
So you all have had a relationship in the past.
Yes, ma'am.
So on October 7th, you were getting calls from his mother.
Yes,
Did you have her number and knew who it was?
yes, I had it saved.
Did you answer those phone calls?
Yes, ma'am, because I was getting calls from her in the middle of the night, having words, so I answered. And, it was Jonathan on the phone. Jonathan wanted to speak to the kids, and I told them that the kids were sleeping because it was a Tuesday night at 11 p.m.
So you didn't allow him to speak with the kids.
Yes, ma'am.
Do y'all have any sort of formal custody order with
No.
these children? Do y'all have kind of an agreement worked out where you can both parent them in different ways?
Yes, ma'am.
So what happened after you told him he could not speak with his children?
He repeatedly called and called and called, repeatedly was messaging me.
About how many times would you say that he called you?
Probably like 8, 10 times he called, was messaging me back to back off his mother's phone.
Did you ever speak to him after that initial call when you told him no?
No.
What happened after he continued to call you?
I got in touch with his sister-in-law, to get his dad's phone number so I can, call his mother to tell his mother that he was trying to get in touch with me and going on my phone and everything.
Was he supposed to be contacting you on October 7th of 2025?
No, ma'am,
Why?
because we have a protection order in place.
Your Honor, can I approach?
Yes.
I'll show you what's gonna mark as State's Exhibit 1. Is this a copy of the effective order that you have?
Yes, ma'am.
A tender State's Exhibit 1 is a certified copy of the effective order.
Object, Your Honor.
State's Exhibit 1 is admitted.
Would you like to see it, Judge?
Yes.
Sorry, could have gotten it a little closer there. And why did you have a protective order against Jonathan Brasino?
Because he abused me for years.
This was when y'all were in a relationship.
Yes, ma'am.
Did it continue after you were in a relationship with him?
When I left him, no, it didn't continue
But it was a continuous thing for a while.
for years.
Are you aware that he was placed on probation for a case earlier in 2025?
Yes, ma'am.
And that was a case that you chose to press charges on.
Yes, ma'am.
Was that the basis of this protective order?
Yes, ma'am.
And how long was this protective order supposed to be in effect?
For 2 years.
And you were aware under this protective order that he was not supposed to be in any contact with you?
Yes, ma'am.
Were there any other things in that protective order that he was not allowed to do?
Wasn't supposed to be in contact with me or within 500 feet within me.
Are you aware that the protective order prevented him from assaulting you or committing any further acts of violence on you?
Yes, ma'am.
So what happened? So let's go back
Hold on,
to,
just a second. Hey, Mr. Brazino, just sit quietly. You'll have a chance to testify. When you nod and shake your head to the responses, that can only mean you're trying to influence my decision. Or are you gonna interrupt me when I speak to? You're just plain rude all the way around. You don't know any of the basic rules. We learned that when we were children. Don't interrupt. That's rude. She's testifying. Sit there quietly. Don't nod. Don't react. Unless it's impossible for you to do that. But let her testify under oath. You'll have a chance to respond if you wish. But shaking your head and nodding your head is only intended to try to influence somebody or to try to respond with a non-vocal type of communication. And you don't do that in this courtroom, okay? Just quietly sit there. If you need to talk to your attorney at any time, do that.
Yes, sir.
Quietly. Thank you. Go ahead.
to segue off of that, Miss Vincent, do you see Jonathan Brasino here in the courtroom today?
Yes, ma'am.
Can you identify him, point him out and identify a piece of clothing he's wearing?
Orange jumpsuit.
Let the record reflect that the witness has identified the defendant.
Yes, it will.
So let's go back to October 7th of 2025. He's calling you multiple times. What happens after that?
I end up hearing banging on my door. My son's screaming in the living room. And so I got up to go look out my window and I see Jonathan trying to push my door open multiple times.
So just, sorry to interrupt, just to clarify, is this the front door of your house?
Yes, ma'am, the front door of my house.
And where, just to give everybody a picture of where everything is situated, where is your bedroom in relation to where the front door is?
So for me being inside the house, my bedroom is from my point of view is the right side of the front door. So his point of view was the left side.
So if you're looking at the house, to the left would be
Yes,
where your
ma'am.
bedroom is, okay. And so from there, you could see him kicking the
Yes,
front
ma'am.
door.
So I started recording him, trying to push my door open, trying to get inside my house. He continued to try until he realized he couldn't, and he seen me in the window recording
What were you using to record?
my iPhone.
So just the cell phone video?
Yes, ma'am.
What happened after he saw you in the window?
He pointed at me and he made a remark and he came to the window and punched it open and crawled through the window and then charged at me.
Did he assault you once he was inside?
Yes, ma'am.
What happened?
He pushed me up against the wall, continued to ask me where is he, whose car is outside.
What happened after that?
I kept repeatedly telling him to ask him to leave, to get out of my house, and to please leave, and he wouldn't.
So he did not have your permission to be inside your house?
No, ma'am.
He did not enter with your consent?
No, ma'am.
Did he take anything from you?
Yes, when he realized that I had my phone in my hand when I was recording, he tried to yank my phone in my hand. That's when he started getting in the wrestling for my phone.
So he was assaulting you while simultaneously trying to get your phone from you?
Yes, ma'am.
What happened after that?
He got my phone. He jumped out the window and, I was trying to get my phone back from him, so I like pulling on his his shirt ripped off. So I jumped out the window with him and followed him. He jumped in his mom's car, he left and I got my car and was trying to follow him to get my phone back, but, I just went to his mom's house because I don't know where he went. He sped off.
So after he left with your phone, you didn't see him again?
No, ma'am, I couldn't catch up to him. He sped off.
Were you at his mother's house when the officers showed up looking for you?
Yes, ma'am.
And what happened after that?
The officers asked me to go back to my house.
And did you drive yourself back to your house after that?
Yes, ma'am.
Did you speak with officers at your house once you got back?
No.
You take a statement?
Yes.
Did you have any physical or visible injuries from what had happened when he broke through your window?
Yes. My right arm was all bruised. Okay.
Do you have any cuts anywhere?
No,
Just bruising?
just bruising.
Did you feel pain from those bruises? Were you ever able to get your phone back?
No.
Were you ever able to retrieve the information that was on your phone?
Yes.
How were you able to do that?
I guess I locked my phone whenever we were wrestling for my phone and everything saved to my iCloud. So the video that I had, it did save to my iCloud.
So it was on your account still and you were
Yes.
able to retrieve it that way? Did you ever see him again that night?
No, ma'am.
Your Honor, may I approach?
Yes.
I'm gonna show you what's been marked as State's Exhibit 2. Do you recognize this?
Yes, ma'am.
Is this a copy of the video that you recorded on your phone that night?
Yes, ma'am.
Has it been, to your knowledge, has it been altered in any way?
No, ma'am.
Is it a fair and accurate representation of what you saw that night? On October 7th, 2025.
Yes, ma'am.
Your Honor, tender States to the defense for inspection.
No objection, Your Honor.
Admitted,
Ask that it be admitted and published.
you may. Do we start at the beginning? Please. The very beginning. Because there appeared to be an image on the defendant outside the house.
Are you talking about the other one?
Yes, Judge, there's two separate videos. Both of them are relatively short.
Okay, and
Give me 1 second, let me get this.
this purports to be the defendant coming through a screen or some sort of.
A window, Your Honor.
That's the window? Okay, I guess, okay. Like, couldn't tell if that was like just an opening in a doorway or that's got a shroud over it that for purposes of privacy or whatever, if it was the window. No, so the defendant is unable to get in the front door by trying to force his way in, so he goes to a window
Yes,
and
Judge.
breaks through the window to get in.
Yes, Judge.
Go ahead.
So just for clarification, I know those videos are very brief. In the time between the first video and the second video, is that when he actually broke the window?
Yeah.
And then you see him entering on that second video.
Yes, ma'am.
So they weren't taken
Yeah.
1 second after another.
Yeah.
There was a span of time when he was breaking through your window. And at any time, did you give him consent to enter your house through your window?
No, ma'am.
At any time, did you give him consent to assault you or take your phone?
No, ma'am.
And this happened on October 7th of 2025, correct?
Yes, ma'am.
And did you have an active protective order issued out of the 317th Judicial District Court at that time? Nothing further for this witness.
Do you know why he was coming over to your house?
From all I knew that he was calling me off his mother's phone to speak to the kids, but
So his intent was come over there to see his kids or talk to his kids?
so they were fucking right here Tuesday.
I'm not saying it's a good parenting move. I'm just saying that's what it seemed like his intent was, correct? That's what it is.
Nothing further for this witness,
Is
Judge.
this lady excused?
Yes, please.
You're excused, ma'am. Next, please.
State rests.
Say, what says defense?
Your Honor, I would like to put on the record that, my client does not want to testify.
Okay.
Right.
So the defense rests.
But I want to make, I'll put on the record so that it knows, or any kind of appeal knows that he chose not to testify.
Okay.
Can you swear him in so you can at least say that part?
Raise your right hand. Do you solemnly swear or affirm any statements you make in the hearing that we're having now as your attorney is questioning you on some matters in this hearing? Is everything going to be the truth, the whole truth, and nothing but the truth, so help you God? Hold your hand.
Mr. Brasino, I have just asked you, did you want to testify and tell your side of the story? Is that correct?
Yes, sir.
And you indicated you do not want to testify. Is that correct?
Yes, sir.
And you're making that choice from your own free will.
Yes, sir.
Thank you, Your Honor.
Also, based upon discussions and advice that you have sought from your attorney. You have to speak out. Yes, you can't take a nod. Okay.
That's right.
So the court finds the defendant is voluntarily and knowingly elected to remain silent, which is his right. Anything else from the parties?
Nothing from.
Summarize the points you want to make and what the state is asking and what the defense is requesting. Thank you. And by the way, State's Exhibit 1 is made a part of the record for all purposes here.
Your Honor, based on the testimony from the officers and from Ms. Vincent, we believe that by the honor to the evidence, the additional allegations on the motion to revoke probation in 24 DCCR 2199 have been proven true. You heard from the officers that responded to the scene. They observed that the window was broken from the outside in. They saw the glass. They did their investigation. They found her, realized that it was not a kidnapping, but did find that there was an active protective order against this defendant by this same victim. This is the same victim that was involved in the original case as well. You then heard from the victim, Mackenzie Vincent, that on October 7th of 2025, she was at her home getting ready to go to sleep. And she began to receive calls from the defendant through his mother's phone. She was well aware that he was not allowed to contact her under the requirements of that protective order. And he not only contacted her as a violation of that protective order, he also showed up at her residence, which is another violation of the protective order. He was not allowed to be within a certain amount of feet from her. He violated that by being at the residence. He then went further and broke into her home through her window and physically assaulted her, causing her pain and bruising, and stole her phone. All of this is a violation of that protective order. It's also a violation of the probation that he was placed on back at the beginning of 2025. And it's a secondary felony of burglary of a habitation. We think all of this evidence is sufficient to revoke him on probation, and we are asking that he serve 10 years in prison.
Defense.
Your Honor, regarding the burglary of habitation, Your Honor, I don't believe the state has established that there was a burglary of habitation. And the reason I say that is I asked the victim one question, which is the key question, is what was his intent? She said his intent was to come over to see his kids and do that. He has to break into the house with the intent to commit theft or commit assault, or I'm sorry, theft or a felon.
I'm gonna
Hold on.
check, Judge.
Didn't he take her phone?
I didn't say he did.
No,
I said
that's
he
what the, isn't that what the
Yes,
testimony
yes, so
is?
it's with the intent or commits a theft or an assault.
Well, I'm still gonna argue that he didn't have the intent to do that, okay? I think that he ended up leaving with the phone. Was not his intent to steal the phone. It was not his intent to assault her. I think he got it.
What was his intent with the phone then, if it wasn't to take it?
I don't know, Your Honor.
Okay, you don't have a backup plan on
I don't
that.
have, I can't say that, Your Honor. I don't know. I can't get in other people's mind. I don't know what anybody's intents are except my own. But I will argue that I did ask that question. We had asked for something less than 10 years. I'm not going to ask the court to continue on probation because I think the court sees what's going on here. But the state's asking for 10 years. We would ask for something less than 10 years.
Oh. Any response from the state, or you stand by?
I stand by my argument, Judge.
All right. The court is going to find that allegations 1, 2, and 3 are of the motion to revoke unadjudicated probation have been proven true by preponderance of the evidence or greater, but in this case beyond a reasonable doubt, as the defendant committed the offense of burglary of a habitation on or about October 7th, 2025. Burglary of a habitation occurs if a person commits an act of breaking into a home or a residence without the effective consent of the owner, and the person enters the habitation with the intent to commit a felony, theft, or an assault. And in this case, it is proven that from the evidence that the defendant stole the victim's phone. A person commits an offense of theft if he unlawfully appropriates property with intent to deprive the owner of property. And appropriation of property is unlawful if it is without the owner's effective consent. Court finds that that has been proven true here in the evidence presented through inference or actual actions shown. Also, the court would note that a person commits the offense of criminal trespass, which this court finds is a lesser included offense of burglary of a habitation, if the person enters property of another and having noticed that the entry was forbidden and was without the effective consent of the person, and there was a violation. There was a protective order in place which ordered the defendant to stay away from the complainant victim in this case, which he failed to do in his entry without her permission of the home, as it is obvious that the defendant forced his way in first by attempting to kick the front door in. When that failed, breaks the window into the home and enters, and then steals the complainant victim's cell phone and leaves the premises with the cell phone after breaking into the home. So, allegation 1, committing the offense of burglary of a habitation on or about October 7th, 2025 in Jefferson County, Texas, is proven true, and it is in violation of condition 1 of his deferred or unadjudicated order, which was do not commit an offense against the laws of the state of Texas or the United States. And burglary of a building and trespassing are both criminal offenses.
Burglary of habitation.
Burglary of a habitation and trespassing are both criminal offenses. Then he committed the offense of violation of a protective order, as he was ordered to stay away from the defendant, which it is shown on video he is not doing, on or about October 7th, 2025, and that was in violation of condition 1 of the deferred adjudication order. Don't commit a crime. Violation of a protective order is a criminal offense, and it is also subject to contempt as well. And the court finds allegation 2 to be proven true. And finally, allegation 3 states that the defendant was at a location other than his residence at approximately 11:57 p.m. on or about October 7th, 2025. And it is obvious from the video, states Exhibit 1, the defendant is breaking into the complainant's home where she had a protective order at or about 11:57 p.m. And that violates a condition 18 of the order of probation, and 18 states that the defendant must be inside his home every day between 10 p.m. and 6 o'clock a.m. except for employment purposes. So allegations 1, 2, and 3 of this motion to revoke unadjudicated probation filed on December 9th of 2025, and this cause number 24 CR 2199 have been proven true by evidence at this hearing. And allegations 4 and 5, failing to provide verification of performing community service hours as required and failing to provide verification of entering and successfully completing the battering, intervention, and prevention program and anger management program, which we refer to as BIPP, as directed by the probation officer, was a violation of condition 26 of his deferred or unadjudicated probation order. So he has committed 5 violations of his probation requirements. The motion to revoke unadjudicated probation is hereby granted. Now, what should be done? State?
Per our previous argument, Judge, the fact that he has not only violated his probation, but committed 2 additional felonies as alleged in this motion to revoke, we are asking for the full 10 years.
Okay. Defense.
Your Honor, we're asking for less. This was a deferred probation. I do not believe he has a record. I'm not sure, but I know if he was given deferred probation, that was some reason. So we'd ask for something more along the lines of 5 years.
Anything you want to say, sir? Talk to John before you say anything so he can help guide you.
That's me, Barbie. It's so just nothing else.
Nothing wrong.
Okay. The court makes the following additional findings: that the defendant has violated allegations 1, 2, 3, 4, and 5 of the motion to revoke unadjudicated probation as filed in this case 24 CR 2199, and this motion was filed on December 9th of 2025. And that is proven by preponderance of the evidence or greater, but the burglary is proven, and trespassing is proven beyond a reasonable doubt, according to the evidence. That is enough to grant this motion to revoke unadjudicated probation. It is hereby granted by preponderance of the evidence or greater, except for the statements the court gives that the burglary and the lesser included offense of criminal trespass are proven beyond a reasonable doubt. 1, 2, 3, 4, and 5 are proven true. And that is enough to grant this motion to revoke probation. Thus, your probation is hereby revoked. Earlier in this case, you pleaded guilty to the indicted offense of assault, family violence, or family house on a family or house member of your family by impeding breath and circulation. You pleaded guilty in that case voluntarily, knowingly, intelligently. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted during your plea hearing to find you guilty beyond a reasonable doubt. Instead, the court placed you on deferred or unadjudicated probation. Now that deferred or unadjudicated probation is revoked, you are hereby found guilty beyond a reasonable doubt of this underlying case, which is this 3rd-degree felony, which alleges in the indictment that you intentionally, knowingly, or recklessly caused bodily injury to the complainant, a member of your family household, or a person with whom you had a dating relationship, by striking the complainant about the head and body with your hands. Further, during commission of the offense, you intentionally, knowingly, or recklessly impeded the normal breathing or circulation of the blood of the complainant by applying pressure to the complainant's throat or neck, or by blocking the complainant's nose or mouth with your hands. In other words, you choked her. You choked her. And that was part of this third-degree felony. Just as a side note, when you put your hands around somebody's neck and squeeze, there's only one intent: to kill or to seriously commit bodily injury. It's necessary to breathe. When you choke somebody, that causes the victim to end up flirting with death or serious bodily injury. Who does that to a person who has a relationship like this? I mean, I've been married a long time. I can't even fathom a thought of doing that, assaulting, hurting somebody I love and care for, much less putting my hands around their neck and squeezing, which is only intended to choke them to death. Well, you have proven you have failed in your actions after admitting guilt and being placed on probation for that terrible deed, choking some person you apparently had a romantic relationship with. Now you've compounded it by burglarizing her home and stealing stuff from her in a fit of childish rage. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. You're a very dangerous person.
You put me away from my kids, bro.
Right here.
But it's okay, though.
Hold on. Hold on. Hold on. Officers, that lady is arrested. She will be held in contempt of court. She committed an outburst in front of this court. She will be held in contempt of court. We're not going to have this. Chaos is not going to rule the day. The rule of law will carry the day. She is being held in contempt of court, committing an act of contempt in front of this court and disrupting the proceedings. That lady, they've got her out there. That's, I guess, his mother. Court is not going to put up with chaos. We've had enough chaos with the defendant in his actions in this relationship that was supposed to be in love, but ended up being assaulted, choking, and then breaking into the home. This is not going to be allowed on this court's watch. The United States of America is supposed to stand for peace and following the rule of law, especially when you're supposed to have a quote love relationship. Ma'am, you are held in contempt of court. I'm sorry, ma'am. You're going to be held in contempt twice. You can be placed in jail for up to 6 months for your outburst, which disrupted this court. Shame on you. What is your full name, ma'am? And how are you related to the defendant? Yeah, okay. Well, now y'all are both in jail. You can't be making outbursts like that, ma'am. And you're interrupting the court, which is just plain, you're still interrupting. You can't help but not follow the rules. You have it on your terms. But this is the law right here. You have a chance to be heard. You can be very upset about what happens, but you can't jump up in the middle of a hearing when we're taking care of matters and start making outbursts, no matter how you feel. If everybody did this, we'd never be able to conduct any business. The business is supposed to be conducted under the rule of law. And that doesn't mean you can't be upset But you can't disrupt the proceedings and then become the focus of attention. Oh. It's difficult for everybody, including the family. All right. Yes, no, take the handcuffs off. She's expressed remorse. And I'm gonna let her go. I know, but still, you have to follow the rule of law. I don't want to put people in jail just because they're family members and they're feeling affection toward their family members, but you can't disrupt the proceedings. That's a violation of the rule of law. Okay, all right, all right. Best wishes. I hope the family can, get out of this and get back together as a family unit. All right, that is all. You are free to go. Anything else from the state or the defense? No, no, we are in recess. Thank you.
Brandon Christopher Missile, 24F242829. Hi, Mr. Westmoreland, good morning. Your name?
Good morning, Your Honor. Attorney Corey Westmoreland, appearing on behalf of Mr. McAuliffe.
McAuliffe, your name?
Brandon Christopher McAuliffe.
Officer, your name?
Sergeant Jeremy Mullins, Flat Rock Police Department, Your Honor.
Hi, good afternoon, Sergeant. So I had him, I took his plea on September the 25th of 25 to a probation violation. I'm gonna need somebody for Emily on this one, somebody for Emily. And he was found guilty or pled guilty to failure to submit the monthly testing as ordered on August 12th, again on September 16th, failed to clear his warrants by July 26th. And we did with regard to the outpatient treatment. I'll find that out momentarily. I set it for sentencing. Show up on October 1. So that's where we are. What does he want to do here? So I'm going to sentence him on the charge. And I don't know what else there is to do. Apparently he didn't want to come to court, I guess. So that's what, that never bodes well for you. So you could I just want you to be aware, Mr. McCall, 90 days on these. Do you understand that?
I do, sir.
Where was he?
Your Honor, he indicated to me that he thought probation was closed out and finished. He's lives in Flat Rock. He is gainfully employed at Richmond Recycling. He was in a bad car accident last November, and that's kind of all.
He thought probation was closed out.
No, to be honest with you, sir.
Well, yeah,
at that point,
I don't want people. Come on. What do you mean?
I'm
You
not.
thought probation was closed out?
That's not what I said. That's not what I
Okay,
said.
well, tell me what the explanation is as to why you weren't here for sentencing back on October 1.
There is no excuse for not being there, obviously. But at that point, I was in a bad situation. I couldn't afford, I got in the accident. I lost my job. I was in the process of losing my home. And I
thought your lawyer
really
just told me the accident didn't happen until November.
Correct.
Well, this had nothing to do with you not being here October 1st then. The accident had nothing to do with that. The accident hadn't happened for at least another month.
Right. This was, I know, I'm sorry, we're leading up to that, but there are just a number of events before that, like I said, I lost my job. I was almost lost my place. And I didn't have the money, I didn't have the means of transportation, I didn't have any of that. So I was trying this whole time from this point till that passed, I have been trying my hardest to get everything back together. I got 2 full-time jobs. I got my place paid off. I'm up, all my back due rent is paid. I'm doing everything and anything I possibly can. Like within this week, I'm trying to go get enrolled in those inpatient programs because I know I still need to complete that. or the outpatient program for you. So this is not for lack of trying or not wanting to try, but like I said, at this point, moving forward, I'm doing the best that I possibly can with my situation. I have put myself in a better mind space, in a better place. I was more worried about what everybody else had going on besides myself. I was putting everybody else first and not even thinking about myself in, in the end, in what it was going to cause to, what was going to happen to me. So, like I said, now I feel like I have set myself up successfully to be
slow
able
down.
to go
Slow
forward
down
and
1
continue and finish this probation.
Slow down 1 second.
Yeah.
Sergeant, where was he? Where was he pulled over last night or picked up, or when was he picked up? Was it this morning or last night?
It was last night. Brownstone Police Department stopped him for a traffic offense. We picked him up on his warrant, Your Honor.
I love how you're sounding like you've seen the light. You've seen the light now, and you weren't coming in here. You got arrested and picked up because of a traffic violation, and and I know that's the only reason you're here.
I swear, Your Honor.
When were
If
you
my
going to come
mother
in
and my
today?
father were here, where they would vouch for me as well. I swear on my life, Your Honor.
You were coming in today or tomorrow?
No.
I've heard that story multiple times too.
No, within the next. I did not want to come in front of you until I had everything lined out to where it looked to you like I am actually putting in forth an effort. That's God's honest truth. I did not want to come in there.
Slow down. Can I see the screenings? Your name, please.
It's my prosecution.
Can I see the? I'm hoping this is going to tell me you don't have any prior convictions. But it's not going to tell me that, is it?
No, sir.
Why did I know it wasn't going to tell me that?
And again, also last night, I was on my way home from work. I was a quarter mile away from my parents' house. That's exactly where I was going when I got pulled over.
You haven't shown up on this case on multiple occasions. What do you think? Anything?
Your Honor, I'm looking, this is an old case, that, Mr. Sino had supervised.
Yeah, it was an offense date of October of 24.
Yeah, and it looks like that she tried to communicate with him in September of 25, then issued the show cause arraignment. Looks like she gave him an effort to show sobriety, sending him to a one-time test. I don't have any proof of treatment, economic crime program. Obviously being called in a warrant, I'm not sure if he has those warrants out of 36 and 19 still today. The only thing that I would have to go back in my office to verify, Your Honor, is he was scheduled for the court work program after this show cause arraignment. I am making the assumption he did not go, but again, I'd have to go look at those sign-in sheets. He was scheduled for October 11, 25, and November 8.
Heather,
and I did those.
Mr. McCall, how much does he owe right now? Anything?
There is a balance of $804.
20?
804.
804, I'm sorry.
And that's what I wanted. I was going to bring that in with me within the next week as well. Correct. I have that. I can have that money not even a week from now.
Your record's bad. You've ignored courts. You've done nothing. I sentenced you on June the 26th. Mr. Westmoreland, anything else?
Yes, Your Honor, it sounds like he's got his life on track. Like he indicated, he is working 2 full-time jobs. He's remained out of trouble. But he does have quite a bit of things that he does need to do, and I would just ask for the opportunity to allow him to continue probation and get everything behind him.
Do anything, right?
Not that I can see, Your Honor. Again, I would like to check on those work days if there's going to be credit. But there is no proof of any progress on the file when it comes to treatment, economic crime program, his testing, so forth and so on.
I did the court work programs. I did do the court work programs.
Can you check that?
I can check that, Your Honor. I'll be right back.
Yep. And as far as anything else going forward, treatment, I am literally currently in the process of getting all of that going. I just started my new job and they're trying to work with my schedule as far as all of this, but that's the other thing. In the past, I was trying to do it and nobody was working with me. You know, I tell them I need a day off for court and or anything, and they'd be like, "Oh, you're missing too much work. We can't keep you here."
I'm not one of those that enjoys absconders.
I know
Think
that
that this
too.
is
I know that, sir.
extremely disrespectful that you didn't come in here and it took an arrest or a traffic stop by Brownstown to get you over here. You were supposed
And
to be, sir, you keep
Yeah.
interrupting me.
I'm sorry.
You were supposed to be here 6 months ago. I'm not buying this that you were going to surrender the court. I'm not buying this that you were going to get into treatment. You had since June 26th of last year. We're into April starting tomorrow. That's
I know.
9 months.
I know, sir.
You've got a bad record. You don't take care of business. You didn't show up on this case in the beginning. How many court work program days did you do?
I did. I had 3 of them and I did 2 and I showed up for the 3rd one, but I was 5 minutes late, so they wouldn't let me complete it. Matter, I have no problem finishing the rest of this, all of these recommendations going forward. I have no problem doing that. And again, I feel like now I'm way better set up to be able to do this now than I was in the past. And again, in the past, I'm not making an excuse for running and not doing anything, but that's just the way it was.
He says he did 2 court work programs.
He did 2, Your Honor. That is correct. 2 out of the 3.
Probation's revoked. You're to pay costs of $800 and serve 90 days, credit 3. I'll give you credit for last night, credit for those 2 for 87 days. If you pay costs of $800, I'll suspend 62 of the 87 and you'll only have to serve 25. That's more than fair. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. I wish you well. If you can pay the 800, you'll be out in 25 days. If not, you're going to serve 87. Any questions, sir?
No, sir.
Good luck to you. Thank you. Thanks, Sergeant. Thank you, Mr. Westmoreland. People against Janaya Amani Ariane Guinea, 25W839-829A.
Everyone has got Miss immediately.
Your name, ma'am?
And I am.
Just put on her.
I arraigned her. I entered a not guilty plea for purposes of arraignment. How does she wish to proceed?
Because I think these have been sorted into 23 violations.
Right.
It's pleading guilty to all the violations we discussed the right now.
So you understand your probation could be revoked. You could be incarcerated for 93 days. True?
Yes.
Did you sign, read, and understand the advice of rights?
Yes.
You plead guilty. You'll be giving up all those rights. And we are not going to have a trial of any kind. Do you understand that?
Yes.
All right. As to count 1, that you failed to attend the court work program on February 21 of 26. How do you plead?
Yes.
Did you fail to attend the court work program on that date?
Yes.
Did you fail to attend the court work program on that date of February 21 of 26?
Yes.
Count 2, that you failed to enroll in weekly testing on February 11th. How do you plead?
Yes.
Count 3, you failed to enroll in weekly testing on February 16 of 26. How do you plead?
Yes.
Did you fail to enroll in testing on those 2 days?
Yes.
Now, counts 4 through 23 all allege failure to submit to SoberLink blows. I've already arraigned her. I'm just going to go ahead and ask, ma'am, did you fail to submit to SoberLink blows pertaining to count 4 on February 4 of 26? On March 4 of 26.
Yes.
So how do you plead to that charge?
Yes.
Count 5, that you failed to submit the blows as ordered on March the 5 of 26. How do you plead?
Yes.
Count 6, that you failed to submit to SoberLink blows on March the 6th. How do you plead? Count 7, that you failed to submit to SoberLink blows on March the 8th. How do you plead? Count 9, that you failed to submit to SoberLink blows on March the 9th of 26. How do you plead? Count 10, that you failed to submit to SoberLink blows on March the 12th of 26. How do you plead? Count 10, that you failed to submit to SoberLink blows on March the 13th. How do you plead? Count 11, that you failed to submit to SoberLink blows on March the 14th. How do you plead? Count 12, that you failed to submit to SoberLink blows on March the 15th. How do you plead? Count 13, that you failed to submit to SoberLink blows on March the 16th of 26. How do you plead? Count 14, that you failed to submit to SoberLink blows on March the 17th. How do you plead? Count 15, that you failed to submit to SoberLink blows as ordered on March the 18th of 26. How do you plead? Count 16, that you failed to submit to SoberLink blows on March the 19th. How do you plead? Count 17, you failed to submit the blows on March the 20th. How do you plead? Count 18, you failed to submit the blows on March the 22nd, 26. How do you plead? Count 19, you failed to submit the blows on March the 23rd of 26. How do you plead? Count 20, that you failed to submit the blows on March the 24th of 26. How do you plead? Count 21, that you failed to submit the blows on March the 25th of 26. How do you plead? And count 22, that you failed to submit the blows on March the 27th of 26. How do you plead? Count 23, you failed to submit the blows on March the 29th. How do you plead? Did you fail to submit to SoberLink blows on March 4th, 5th, 6th, 8th, 9th, 12th, 13th, 14th, 15th, 16th, 17th, 18th, 19th, 20, 22, 23, 24, 25, 27, and 29? Anybody force you to plead guilty?
No.
Why? What's going on now?
Judge, clearly, she's off to a court start on probation. Ms. Lagarde.
Who's this with you? How old are you?
We came up with the same potential solution in the time of leave that, maybe a charter would be a good idea.
Can I see the screen? Do you work?
Yes.
Where?
Yes.
What do you do there? Now, listen, I'm not boring you, am I? What are you yawning like that for? Are you tired? I'm asking you a question.
No.
Well, why are you yawning if you're not tired and I'm not boring you?
You just came.
Did you take care of this ticket out of 25th District Court for driving under the influence?
No, I took care of Taylor and
Why don't you go over to the 25th District Court and take care of that?
I was waiting on my check.
How immature are you?
Huh?
How immature are you?
I'm very sure.
Who are you living with?
I live with my sister. I live with two people. My mom and sister.
How long you been working at DMC?
Just started. I was in school.
Where were you going to school at?
Phlebotomy career training in Dearborn.
Did you graduate?
Yeah.
You said phlebotomy training?
Yes. Preventive was scan.
Well, I only sentenced you February 4th. Reports as a student, no income, $200 a month of bridge card benefits, single, no children. Graduated high school at 19. I ordered you to clear all your warrants by March the 1. You didn't do that. You got a big problem here, and I'm trying to figure out how I can do to save you. You cannot do this. You can't just ignore courts like this. I don't know what you're thinking. I mean, you put yourself in a horrible position here. Sir, you got to get her to grow up, or life's going to be an awful long experience, not a pleasant one. Wow. And you were then the one bawling out here in the courthouse in the hallway? What realization that you can't just thumb your nose at a court? Is that what it was?
It's no, so I don't understand. Stuff like this, I'm not really a bad person. I don't have a problem with doing it, but when it's just about my time, right? I'm really fast, so the time it just a lot in my head. And I get thrown off because I'll be doing one specific thing I know. So it just be a lot. And then I'm like lifting here, plus therapies. It's like all this is taking my money for me to even eat or have stuff to kind of like be able to handle my business. It's just a lot. It is a lot. I'm young, I'm not 24, I don't have no kids. So I'm trying to do the best I can by giving all my money away and stuff like that. I'm paying these tickets. It's just, it is a lot. It's making me forget things and stuff.
You didn't go over to the 25th like I told you by March 1, surrender on the warrant. I'm not excited about that. That was an OUIL. It's an OWI. I don't know what you're thinking. I really don't. I mean, I'm finding this one hard to believe. You did nothing. 23 counts of a probation violation. I could count on one finger probably the number of times I've gone to 23 counts on a probation violation. I'm serious. I mean, I'm not sure you've left me with any choice here. And the choice that you have left me with is not one that you're going to want. I don't know what to say. Can you give something positive to me?
She is enrolled at the guidance center. She's going twice weekly, once for individual therapy, once for group sessions. She did get enrolled in that beginning, about the middle of the month in March. I was told about that. Again, I don't understand that it's a lot of stuff all at first, but when she was sentenced, I went over everything with her. I gave her all the paperwork. I then sent her an email that has all of her stuff listed out for her. When she missed testing, the first time she did call me on an unrelated matter, and I gave her the opportunity to go again on the 16th for testing to make up for that miss. She still didn't go, didn't reach out to me.
She's still drinking and or drugged.
That's it. I can't prove it.
There's no, you can't convince me otherwise.
No, I'm not drinking. I don't have a problem. Not drinking. That's not the issue. It's just I don't have no ride, sir. I don't have no ride. I'm using my lift.
You had a sober link device that should be right with you at all times.
I'm blown.
Well, why did you have to get a ride to go take the sober link? You've missed all these tests. You've missed somewhere in the neighborhood of 60 or 70 tests.
The problem is I'm just not blowing at the correct time you guys have. Like you had me blow 7 a.m. I'm already at work. You know what I'm saying? So it's like
we talked about changing her testing time when she was sent.
that's just the problem. I'm blowing. It's just not the right time.
All right.
That makes sense.
Judge, there are times when she is late on the blows, but I didn't even include all the late ones. I just included the ones that she missed completely or was over 3 hours late on.
All right. Well, you got 23 technical violations here. Okay. Now, you cannot do this. You cannot do this.
Judge, if I could.
Yep.
If she's to remain on probation, my recommendation moving forward is that she have a scram tether.
Oh, yeah, I know. I'm already writing that down. I'm not gonna assess any costs. I'm gonna give you a break. But it's not gonna be a break that you're gonna like. We're gonna, SoberLink is to be replaced with a scram when she's released from jail, 8 days jail, should be 80. So don't be complaining or crying about it on your way out of here. Do we understand one another? 8 days. That is a Christmas gift in March. Good luck. You no cost. And then you're gonna coordinate getting the scram off or the sober link for the scram, right? Thank you. Do I have anything else this morning, John?
No, we do have an unidentified phone number out here and I can't chat with a phone
Where's on the
number.
515-705-442012, it looks like. Can you tell us your name, please? You're gonna have to have a seat in the jury box, man. You gotta grow up, young lady. I'm giving you a chance now. You better follow through.
Mr. Norwood,
Sir.
you're hearing me talk about something you have no interest in, but I'm waiting for the jail to turn the camera on.
Yeah, they can't seem to figure it out.
All right, well, can you see me?
Yes, I can, sir.
All right, how do I look?
Distinguished is the word. Distinguished.
That's not a very good answer, but.
Your sentencing today, Judge, is fabulous. The answer is fabulous. I'll answer on his behalf.
All right, let's do the best we can with what we have. We know who you are. For your information, Daniel Frazon, your probation agent, is here. Also, Mr. John Bush, originally happened to be here on another matter, and I asked him to sit in on this. You got arrested last night for a probation violation, and it appears you may also have a new criminal charge of retail fraud.
Sheets were submitted last night and they just received them this morning at the prosecutor's office for 2 retail seconds. They're actually 4 different incidences.
All right, well, the allegation here is that you violated your probation by having contact with your mother. And Daniel was about to file a probation violation petition.
It's filed, it just hasn't been
It's
set.
filed. He and I spent a lot of time on this case, and we were very hopeful. You got into that culinary program. It was going to solve a lot of problems for you and your family. And then the wheels fell off. February 13th, missed testing, refused. February 15th, failed to report. February 17th, February 23rd, March 6th, March 12th, March 17th, missed testing. Daniel tried to call you on March 18th, no response. You didn't report on March 19th. And you told him you were going into inpatient treatment, but that apparently wasn't true. So Daniel's recommendation is that your probation be revoked, and I order the 90 days of jail that was deferred.
Your Honor?
Yes.
I have a question, because this is kind of something I haven't had to deal with before. As he was already sentenced to the 90 days and he was only to be released to inpatient, my understanding and my thinking, and I'm not a lawyer, but he could just be served out the rest of his 90 days and then we just had to have the hearing on the revocation, correct?
Yes.
I was just curious. I hadn't run into this before.
Anyway, I'm gonna set this for a probation violation hearing. This caught Mr. Bush unaware. He just happened to be here on another case. And, but I ordered 90 days. I allowed you to get out to go into inpatient treatment. You didn't go into inpatient treatment. There's also the issue of just revoking the probation. You've also got some new charges of retail fraud that's apparently being authorized as we speak. So I'll set for a PV hearing. I'll try to do this next week because I'm leaving on a trip.
You need me to get my calendar out, Your Honor?
All right.
Yeah, I'd like to get a different lawyer too. I don't want
Why is
Mr.
that?
Bush. Because Mr. Bush is crap.
Well, you can hire one if you'd like.
No, I'd like to fire him and get a new one.
Well, Mr. Bush isn't the source of your current set of problems. You failed on your probation by failing to test, failing to report.
No, the system
got
failed on
arrested
me.
on some new
You guys
charges
failed
and
on
you
me.
lied.
I didn't have the resources I needed when I got out. You guys messed up on me. So,
Well, perhaps.
yeah, perhaps.
But it certainly isn't Mr. Bush's fault. That's one way to look at it. Rather than accept responsibility for your own shortcomings, you blame us. We always could do better. I certainly would concede that if we had unlimited resources and cooperative, willing participants.
You should have never dropped me off in the streets.
Yeah, so the program you were gonna go into, Daniel and I were both very excited about it. It was
Yeah,
gonna
so
pay
was
your
I.
housing, it was gonna,
So was I, but you guys dropped the ball on me.
well, I'm sorry.
Yeah.
Sometimes it's real heavy. John, are you available Thursday afternoon? The second.
I don't want that trunk
2:30?
fucking represent. No, fuck it. No, fuck it. Fucking drunk.
Yeah, I'm leaving for a long
All right,
weekend.
when do you leave?
I'm leaving Thursday and I'll come back Tuesday.
All right, let's see what we got. V8. Are you available in the morning of Wednesday, April 8th? Say
Yes, Your Honor.
10:30,
I
April
can
8th.
do that.
Yeah, if you need that. If they don't be here, maybe they're gonna leave you.
All right. We'll find out more about this and your request for a new lawyer, but we'll set everything for a hearing on April 8th. Your bond is canceled.
Yeah, of course it is.
Yes, it is. I wish I could see you. Maybe we could communicate better, but I will see you live and in person next Wednesday at 8:30. You can go back and I'll see you then. And the magistrate will see you later on these new retail fraud charges. All right. Daniel, thanks for your help. I'm not clear what happened to the culinary program.
Well, I spent a lot of time calling and coordinating stuff. I had spoken to Mr. Wright several times. It was supposed to go into the teen challenge last minute. That didn't work. The culinary actually sounded a little bit better because it could have house his family
Yes.
as well, which was really good. And I spoke to Derek there, who had a similar background. He's really made a heck of a way for himself and he wants to help other people's. And they get a skill of the culinary, they get him a job afterwards and they do treatment while they're there. So
Yeah,
it
it was
really good
sounded
program.
like a great program and it was
He
free.
said he was all set to go, but then 2-3 weeks after this flopping around, I said to him, Mr. Wright, what's going on? Oh, I need a letter of recommendation for you. I said, okay. So I sent him it the next day and then I called Derek to find out if he'd followed through with it. He didn't. And I talked to Heather, who coordinates the program. And she said that she hasn't heard anything from him in like 2 or 3 weeks. They had a bed waiting for him and he just never came up. And then he stopped returning my phone calls. So my guess is things went south as far as the substance abuse, but
Yes.
I
Well,
would know
we'll
because
find
I
out.
get tested.
Mr. Bush, thanks for letting me,
What is his first name again?
his name is Christopher, Krstopher.
Thank you.
Right, WRIG.
We'll have to resurrect his file out of the archive.
You'll remember it. He had a Scandinavian wife who is here, and his mother, and there's big substance abuse issues, and we've been trying to get him somewhere. We spent as much time on any client in 2025 that we spent on him, and apparently that wasn't enough for him.
It's never enough. Ladies and gentlemen, this is a lesson I've learned very well. It's never enough. And ladies and gentlemen, it doesn't always have to be enough, because when it comes to stuff like this, it's happening all the time. And I just don't have enough time to show it all. That everything that happened today, right now, the last 2 hours. So we'll get to it later. We have a big weekend show shaping up right now. I'm not giving any hints to it just yet, but I'm just letting you know. Be prepared. The weekend court review this Saturday at noon Eastern time is going to be very. We do the same daily court watch every day at 8 p.m. Central Time. Isn't that right? 9 p.m. Eastern Time, chat. Is that right? Thank you for hanging out, Charlene, Felix, Rhonda, Eileen, Kiernoth, Kimby. I've seen some new names. I'm not saying any of those that I just said are new. Bro, I know your name isn't necessarily new. Wixom, I know your name isn't new, and I saw it in there somewhere too. What are the other names I saw? What are the... I know I need to do this thing where I say, hey, Kiernoth, Scott McIntyre. Oh my God, thank you so much. I didn't pause when you gave me your donations. Golly, thank you so much. I greatly appreciate the super chats. Any type of donations y'all send. Thank you so very much. It supports the channels and the pups, and they appreciate it very much. Let's do it. Ladies and gentlemen, that's all I got. That's it. I'm your lone wolf Fusel. I'm your humble host for these here little get-togethers, and you know, I make the videos and I do the little archiving thing. I'm your wannabe archivist. These here court hearings from around the court tube spectrum, found on YouTube and elsewhere in the world, mostly on YouTube. Guys, thank you for hanging out with me. I hope very much you've enjoyed yourself, and I hope very much that I'll see you next time. I'm your lone wolf Fusel, and I am out. Well, for a minute at least. If you know, you know. Felix, did I say goodnight to you? Good night, Felix. Good night, Shiloh. Good night, Steven. Thor! I don't think I said good night to you. Cat! I'm just going to start reading names as they pop up. If your name pops up, I'm going to read it. Will you make your name pop up? Anybody? Anybody? Oh, wow. Mama Wolfie, Felix. Hey. Hermeticus Kimby. You guys ate great too. Thank you for coming by, Thorn. Living like a cat, great to see. I am prepared. Tonight, I come to you, a host who is prepared for this homage to Ferris Bueller greatness. We're done here. You don't need to be here anymore. You can leave. Goodbye. It's not necessarily to be here. But if you are here, a moment of wisdom for you. Just remember, women are crazy. Men are stupid. The main reason women are crazy is that men are stupid.